Hello, I'm Belinda Conaway, your Register of Wills for Baltimore City. Welcome to The Will, a show dedicated to informing you, the citizens, about information related to wills and estates. This week's episode is one of a three-part series featuring two of our great Baltimore City Register of Wills team members, Gaines Landsey and Calvin Richardson. The focus of this show is the distribution phase of the probate process. We will answer questions about the distribution of a decedent's assets and discuss some of the challenges that you may face, the timelines involved, and fees that may be incurred by an estate. As I always say, I want you to have this information now so that you can be proactive and deal more easily with the often difficult and confusing process of probate. I'm Belinda Conaway, your Register of Wills for Baltimore City. Instead of making your usual New Year's resolutions that fall by the wayside in a few weeks, why not do something that will protect your assets that you've worked so hard for? Write your will today. Be sure to visit us on Facebook at Row Baltimore City or call 410-752-5131. And remember, where there's a will, there's a way. Welcome back to The Will. I'm your host, Belinda Conaway, your Register of Wills for Baltimore City. Today, we're going to talk about the distribution phase of the probate process. We want this to be a proactive discussion about how to manage the distribution of assets, since death always affects those who are living. As always, I'm joined by two fantastic guests. Calvin Richardson works in our audit department, and Mr. Gaines Landsey is in our Welcome Center and also works with our outreach team. Thank you both for being here today.
Thank you.
Thank you.
Before we get started, I always want to remind you, the citizens, that we strongly encourage you to call our office first with any questions. We will arm you with valuable information to help minimize the number of visits necessary to complete estate business. You may reach the Register of Wills office for Baltimore City at 410-752-5131. Helpful information, checklists, and forms are also available on our website, www.registers.maryland.gov. You can always reach us on Facebook at Row Baltimore City. I personally believe that proper preparation and planning prevents chaos and disorder, which ultimately leads to a smoother transition when our loved ones pass away. As we've mentioned on other shows, the probate process sometimes goes on for 6 months, but we have seen families in the probate process for up to 20 years. Let's be prepared so that you can avoid this if possible. So let's recap before we move on to the distribution of an estate. You need to understand that the process of opening the estate with our offices can be done rather quickly and efficiently with the right paperwork and the right information. However, depending on the size and complexity of the estate, it can be done in a few days, or in some cases, take years to finally be able to close it out, depending upon how the assets are to be distributed and if they are all available at that time. If you may remember, the Tom Clancy estate has been open for years based on continued book royalties, movies, and other such assets continuing to come into the estate. Whoever is assigned to be the personal representative in the will, or who comes into our office with the proper paperwork and qualifies to be the personal representative without a will ultimately secure control over the estate throughout the duration of the probate process. However, even those assigned as the personal representative in the will can be disqualified as the state executor if in fact someone files to have them removed as the personal representative with the Orphans Court and shows just cause why they can't serve, or if that person has been convicted of fraud, extortion, embezzlement, forgery, perjury, theft, or any other serious crime that reflects adversely on their trustworthiness, and that's state law. If none of the immediate family members or heirs want to serve as a personal representative, someone else can be the personal representative and open and maintain an estate by filing a petition with the Orphans Court and receiving the permission of the court. You need to understand that there are typically two kinds of estates, a small estate and a regular estate. The small estate is when someone has assets that total less than $50,000 in value upon their date of death, whereas a regular estate represents someone with assets greater than $50,000. All estates require a personal representative to serve as an executor in order to distribute assets, file proper paperwork in a timely manner, and ultimately be responsible for the estate itself. The length and complexity of an estate really depends on multiple factors, such as the assets involved, the number of heirs or interested persons, whether or not bond is needed, and if everyone involved in the estate signs off on the waiver or not, whether you have to run notice in the newspaper, the degree to which the heirs cooperate with the personal representative, and so much more. But we will try to help navigate you through all of this on this program of the will. So let's talk about the path to distribution. Mr. Richardson, walk us through a few examples of successful distribution of funds, and then call our attention to a few complex cases where it might have helped to be better prepared.
Okay, thank you. The beginning of distribution to an estate begins with the 6-month probation period, the waiting of the clearing of the assets of the estate. Once that has been done, the personal representative can come into our office to the audit department and fill out what is called an administration account. The administration account is the reporting of the assets of the estate per the inventory. Those assets are probated assets listed with a value of date of death. An example of, let's say, an easy estate for distribution is a sole heir, a piece of property of estate value of $139,000, and a vehicle of $12,000. No cash asset in the estate. If there are no claims against the estate, which is very important, that's the first thing that we do. The first most important thing that we do. We ensure that the estate is clear of all claims. If there are any claims against the estate, that prevents the closing and distribution, any distribution of any assets of the estate.
Okay, so when you say claims, this is advertised in the newspaper.
Exactly.
And it gives people an opportunity to say that the decedent owes them money.
As part of their 6 months probation period. The notice being run through the daily record, and again, giving them that opportunity to come forth and place a debt that is owed to them through the estate of the deceased.
Okay, so people can look for those ads in the Daily Record or the Sun newspaper.
Exactly.
And find out that an estate has been opened, and then they have an opportunity to come and say that money is owed to them, and so they want to have an opportunity to have that amount paid through the estate.
Yes, ma'am.
Okay, and so that comes to your department?
No, ma'am. That comes to our record department. All claims are filed through our record department, again, within that 6 months period of time. Anything after the 6 months period of time gives the personal representative or the attorney, whomever which one is representing the estate, the opportunity to file a disallowance, which gives them the opportunity to say that we disagree with this amount that you place against the claim against the estate. And that lasts for 6 months. After 6 months, if the courts haven't received a response from that disallowance file, then they will allow that disallowance to go through as a zero claim against the estate, and that claim will be dropped from the charge of the estate.
So you look over all of the claims against the estate, and so when people get into the distributions, and we talked about in the first example, just one piece of property.
One piece of property in a vehicle.
Okay.
We go through that process of elimination of the claims. We then look for the fees that are due to the Register of Wills. And the way that we calculate that is we total the estate. The estate that would be totaled determines the value of date of that asset of those two piece properties that we just mentioned. We have a scale of a probate fee chart that tells us the amount of probate fee that is due by state regulated law to the Register of Wills for the probate of this estate, meaning everything that we handle, all of the documentation, everything that comes and flows through the Register of Wills involving this estate. Once we determine that, and the example that we are speaking of now, this estate probate fee will be $400. Depending on the date of death, if inheritance taxes would be included. If the date of death, let's give an example, is of 2016, no inheritance tax to direct heir, being a spouse, children, grandparents, stepchildren are exempted from inheritance tax. All of the heirs below that are subject to a 10% inheritance tax, unless there is a will. That's another important item that we must look at. We must look at the will to determine, if there is a will, to determine how distribution is to be done. Specifically, a deceased person will specify in their will how they want their property or their items of their belongings to be distributed among their surviving loved ones. Let's say in this case, there's just a sole heir and everything is to be given to that sole heir. Once we determine the fees that are due to the Register of Wills, we also discuss with the personal representative any other fees, estate related, that they may have come out of pocket to handle the expenses of the estate. Once those are calculated, we take those away from the total estate and distribute, be it in cash value or an asset value, in this case, which that would only be the property, the total value of the property, and the total value of the vehicle. You cannot take away a cash asset value away from an expense. That can't be done because it hasn't been sold. That property and that value will then go to that sole heir.
Okay, and so when you talk about the expenses of the estate, we know that there's an expense for listing the ad in the newspaper.
Yes.
There may be expenses for the death certificates.
Yes.
If there's a bond that people have to secure a bond,
Yes.
there's an expense for that.
Yes.
Do you have other examples of expenses that people may not be aware of?
What we will do is we will go through the charge sheet. We will check our charge sheet in our system to view if any expenses have been paid previously through the Register of Wills. The certified mail fee, a small estate fee, if there are any applied, and the bond, the daily record. Those will be calculated. There are also allowances that the personal representative would be allowed depending on their decision on the distribution of those assets. If they wish to keep the property in kind through distribution, then they are allowed to show the expense of 1 year's homeowner's insurance, 1 year's property tax, 3 months BG&E, and 3 months water bill. That's an allowable allowance to them in keeping property in kind. If they decide to sell the property, then that means distribution is not going to be done, for the simple fact that they want to show expenses of the maintaining or preparing this property to be sold, retaining that asset for future. Once the property is sold, then everything will be calculated. All proceeds from the sale of the property would then be turned over to that heir.
Okay, so some of the expenses that you talked about, these are expenses for maintaining the property.
Yes.
While people go through that process. Those regular expenses, water bill,
Yes.
gas and electric bill,
Yes.
keeping up the property taxes on the home.
Yes.
What about the homeowner's insurance?
As long as the property is on the market for sale, any expenses occurring, the homeowner's insurance, property tax, ground rent, all expenses are allowable through the expense portion of preparing the property for sale. They can claim those expenses, reimbursement be out of pocket or from the estate assets itself.
So what it really sounds like is whoever's personal representative really needs to make sure that they keep track of any expenses that they have and keep their receipts and things, so that when it comes time to distribute assets, they can be reimbursed for out-of-pocket expenses.
Exactly. I always implore, our department always employ all personal representatives, please keep a record. Our office, we do not collect or view these receipts, but the courts at any given time may question any expense that they feel that is out of the ordinary, or they feel that is, oh, this is too much, it doesn't look right. Then they will, without a doubt, continue the filing of that administration account pending that they supply proof of payment of certain fees that they say they may have paid, certain expenses that they say that the estate may have incurred.
Okay, so just like anything else, if you have expenses that you put down, you should have receipts for them and documentation for it. That's really, really important information. Mr. Landsey, you and I are often out in the community trying to help educate people and talk about the importance of having a will. So what kind of questions do you get from people about the probate process when you're out in the community?
Well, thanks, Ms. Conway, and thanks again for having me on the broadcast. What we generally hear from the community, or the community is surprised to hear from us, is who can open an estate, what category they all fall under, and what do I do, what do I have to report, why do I have to report it, and I don't know anything about it, so is there somebody that can help me? Well, needless to say, we can address all of those questions with the client, or potential client, because it's very, very simple through our office, and you've helped to streamline that, because the Welcome Center will advise the customer exactly what they need to do, what they need to present to us at the time the estate's open. There are fees that are going to be due to the state of Maryland through the register, and there is a desire for the whole process to be a one-stop shop, as you often say. We want that person's time, whose time is as valuable as ours is, to come into us prepared, to be able to let us assist them in that process. That is probably the most interesting questions we do get. Other questions get more detailed, and I'm sure we'll address that in other episodes.
Absolutely, absolutely. And I know that one of the questions that I get, particularly from younger people, is why do I need a will? And, you know, so I normally ask questions like, well, do you have a bank account? Do you have a car? Do you have children? And so, you know, those are things that people need to consider. Some people like to put off making their will, but if you have these things like a family, children, husband, family, a car, a house, then you need a will.
Well, you're absolutely right, Ms. Conway. And the biggest part of that is these are the last desires of the now faithfully departed. So what that person wanted done, they make it clear to whomever they want to be appointed personal representative of their estate. That individual is somebody that the now deceased has confidence in, that will do exactly what their desires are upon their death. They'll do it honestly. They will maintain their fiduciary responsibility. They will see to it that everything that you wanted done is completed and can be accounted for. If they have charitable organizations and they want that charity to receive information, or the grandson or granddaughter to receive the 2 vehicles, then they make that clear that's what they want. Same thing with the property. Oftentimes the second generation, third generation really has moved on to another area of the city or area of the state, and they're trying to hold on to a house that they no longer have an interest in. But there's somebody still living there. So the mother, father, whomever the last to the deceased is, will say, I want this property to go to my daughter who's taken care of me for the last 30 years. I'm grateful for what she has done. That's an expression that they want to make sure is in the will. They also would want to put that in the deed as well. But these are some of the things that we address as a part of your community outreach procedure, and it's been very, very well received, and you are to be commended, Mrs. Conway.
Well, thank you. You also made a good point when we talked about people that have children, but also as your life changes. You know, there are things that happen. You have grandchildren, or you know, there's a marriage or whatever it is. We want people to be reminded how important it is to update that will. Even if you have one, if the will is 20 years old and life circumstances have changed, your family dynamics may have changed, it's very important to update your will so that the assets you've worked so hard for will be distributed in a way that you would want them distributed.
And you're absolutely right. In fact, it's much easier than people think, because the mindset of the general public is that they need a new will. That's fine if you want to create a new will, but there's a vehicle that will let you address all those issues called a codicil. And that codicil is an amendment to the will that reflects exactly what has changed in that person's life. If the house is already sold and gone, we know that there's only going to be an asset of a vehicle, and that $59,000 they have in the bank account that were in the deceased's name alone. We don't charge the client for assets that are jointly held, as you well know. But that codicil will definitely make it very, very clear that this is an addendum to the existing will. But again, they can always create a new will that says that it nullifies any previous last will and testament. They can also file that just as they did their first will, which is as a safekeeping will, which, as you know, goes into our vault. We provide a receipt to the client, because for that $5 fee, they have peace of mind, and upon their death, the person knows exactly where to come and take care of the business of the departed.
Absolutely, absolutely, very important. And we always encourage people to call 410-752-5131. You can ask questions about this process, find out what you need to do, if you need to change your will or if you want to replace it. Your will goes into a sealed envelope. It has your Social Security number on it, and then we don't open it until someone brings in a death certificate, and then we look to see who the personal representative is. But until then, your will is left sealed in an envelope. If you need to make changes, call, find out what the process is so that it can be a smooth, easy transaction. You can get in and get out and take care of that. But updating the will is very important because we know that things change in life. And as things change, so should our will, as well as updating other important paperwork, bank records, those 401ks and life insurance policies, everything, all of the things that you work for to have, that you can make sure that these things go to the people that you want to have them. It's very, very important.
Yes.
Your assets, what you've worked for.
Yes.
Absolutely.
Have to believe that. Without a will, and you do have specific wishes of which you want done with what you worked hard for, will fall into what is called intestate law. That means no matter what you may have felt you want to have done, without that will, it is not going to happen. That means that that child that you may have, for whatever reason, wanted to leave out and you just wanted that one specific person to have, it will not happen. For the simple fact that you are a mother and you have 4 children. If you just wanted that one child to receive, let's say, your home, and that's all that was that you had, that you left, and you wanted that one child, as you gave an example of earlier, without that will, it falls under intestate law. That means those other children are to receive an equal share of that property.
Right. So without the will, we don't know what your wishes are.
Exactly.
So we follow state law.
Exactly.
State law that tells us how to distribute those assets.
Exactly.
Yes, and we get that more and more through our office because oftentimes the clients that come into us said, we were just about to do the will. Mm-hmm. Now the person who's now deceased was 92 years old, and I guess they were just about to do the will for the last 70 years. So that's what happens in the mindset of some of our customers. There's always tomorrow.
Yeah.
And tomorrow sometimes comes a lot sooner than today.
Exactly.
Right. Absolutely. I think most people would like to think that they'll live forever, but that doesn't happen. It just doesn't happen. So we have to be prepared. And part of that is conversations like these, conversations that are sometimes uncomfortable.
Exactly.
But you know that they're important. And making sure that you talk to your children about your assets, you talk to your family members, so that you can appropriately designate who you want to have what. And that makes it so much easier for the family when a loved one passes. It becomes very difficult when the decedent has not expressed their wishes, and now you have family members who are in the grieving process, but on top of that trying to figure it out, how to distribute these assets and what to do with them. So that will becomes an extremely important document so that we know, the Register of Wills office knows who is supposed to get what.
And you're absolutely right, because that's what your community outreach is all about, to get that message out there so the general public knows. And you're making it very, very convenient for us to go out into the community and meet with churches, civic organizations, just people who have a general interest. The biggest portion, though, is senior citizens. And they're the ones that are most likely, more than likely, to be in need of this information at their earliest convenience. So, as you say, where there's a will,
there's a way. Absolutely. But also for people who have families, have children, just having this taken care of, write your will, get it out of the way, it's done. And at least you know that should something happen to you, that your children are taken care of, that the assets are allotted the way that you would want them to be.
May I make one additional comment related to the will? And that is that a will does not, currently under Maryland law, does not have to be notarized as long as the testatrix has signed, and generally we prefer it be dated as well, and is witnessed by two individuals, then that's going to give the will that validity it needs to have to be implemented as a part of the estate. And let me also mention that they need to bring the original will or the original codicil in whenever they're making a change or replacing a will or doing anything that falls under that category. It has to be the original document that we take in, but it's already sealed by the person who's depositing it, so that again, we don't open that will, we don't exhibit the will until proof of death is provided to us.
Okay, so an inventory report is a part of what has to be filed during this process. So tell us about that inventory report. What is it? What goes on the inventory report?
The inventory report is the basis and the biggest part of the filing and showing of distribution of the assets of the estate. We always begin with filing the administration account with the assets of the inventory. The inventory schedule runs A through F, listing various assets: real property, leasehold property, tangible property, stocks, bonds, other assets that may have been part of the decedent's estate. We determine, when we look at those things, we determine, okay, what is and what isn't probatable. Normally when it's already on the inventory, it's probated assets. From that point, if there's nothing else coming into the estate after the filing of the inventory, which will be considered as additional assets, we will begin the filing of the administration account with those assets and those assets alone.
Okay, so when you talk about an inventory sheet, you're talking about that's where you list the houses,
Exactly.
cars,
Exactly.
bank accounts,
Exactly. Stocks, bonds.
stocks and bonds. Okay.
Any asset that has been appraised. It could be jewelry, household items. If it has a certified appraisal and has been entered into the estate, it will be listed on that inventory and will be considered as part of the estate to be distributed.
Okay, so that's good information. So, for example, a person that has expensive jewelry, that needs a certified appraisal.
Yes.
And then it's put on the inventory.
It's put on the inventory.
It's part of the assets.
Of the estate.
Okay, of the estate. Okay, and so that kind of, we build out from there.
Yes.
Okay, that's the basis.
Yes.
You look at all of the important things, all of the valuable things. What about the smaller things that people come across? A string of pearls, fine china that may have been passed down for generations. What about those kinds of things?
Okay, those items, if they are later found to belong to the decedent, they have to be appraised. They have to be appraised and then brought into the estate value. Once that is done, then we can include that, and then that will be calculated into the total estate value of what it should be to be distributed.
And that, I think that really gives another important reason for people having a will and having these discussions, because too many times there are valuable items in the estate and people just don't know it. There may be collector's items that you have, and perhaps the grandchildren don't know that you have this great collection of items.
Exactly.
And so some of these things end up being donated to Goodwill or discarded because people don't know that there's value associated with them. So, once again, we encourage people to have a will and to put these important things in that document so that these assets can be passed on to someone who really wants them. Okay, so we talked about the timeline for the distribution of assets. And we know that it could be as little as 6 months. What is it that causes the distribution of assets to be held up? What causes that timeline to expand into a year, 3 years, 10 years?
It can range from various situations, from as simple as documentation required by the courts to fulfill the obligations to complete this administration account for distribution, all the way to the disagreement of heirs in the distribution of a piece of property, who is to receive what share, petitions being filed. Let's just say that the administration account has been completed, meaning that the inventory has been reviewed, all expenses have been calculated and placed on this administration account. Distribution has even been shown evenly between heirs, but it goes to court and you have a heir that disagrees with that distribution. They file a grievance with the court stating that they disagree with the filing of that. That can delay it. That means that the court is going to hold a hearing or ask for the accounting to be refiled, giving the personal representative another opportunity to go back, review what it is that they filed, and show the distribution in another manner. It could be something as simple as pending sale of a property, foreclosure of a property. And we all know foreclosure takes, no one knows how long. To close out an estate, if you just have a piece of property and none of the heirs want the property, which is totally up to the personal representative, whether they want to distribute it or just to let it go into foreclosure. That process can take years.
Okay, so there are times when things are quite simple and you're able to close out the estate, and then there are other times when there are problems with heirs and they have disagreements about how things are distributed or the expenses of the account. Exactly. And then they can go into the orphans court and plead their case. Yes. Before the judge. But this can all hold up the assets being distributed. Yes. For an estate. Okay, so let's talk about distribution. We know that people can have a will, or if they don't have a will, we call that intestate. Yes. So let's talk about the distribution of assets if a person has a will.
Okay. The distribution per the will is simply those assets. Once we determine the total estate to be accounted for, minus the expenses of the estate, the probate fee, the bond, the daily record, any other estate-related expenses.
The funeral.
The funeral. Okay. What's to be left once the expenses is what's to be distributed according to the will, if there is a will. If distribution is to be divided equally among the children, if there's a piece of property and they wish to keep that property in kind and not sell it, that means 4 children, if there are 4 children listed in the will to receive that property through distribution, then they all 4 will receive 1/4 share, equal share in the value, the date of death, inventoried value of that property. And that is how the distribution is done. Once that is agreed upon with the personal representative, then that accounting is forwarded to the orphans court for review and approval. Once that has been approved, then they have 20 days to file a grievance of disapproval of the filing of the administration account and the distribution showing of those assets. Once that is done, the estate is considered closed and distribution can be done. We always employ, if there's just property, to please have the deed titled over to those that it's been shown on the distribution list, because later on it can create a big havoc. If someone dies and that property hasn't been deeded over, that share reverts back into the estate of the first deceased. and that creates a problem.
Okay, very interesting and good information to know. Now tell us about when someone does not have a will and how you go about the distribution of assets.
Okay. Distribution of assets on an estate that doesn't have a will is done by intestate law. Let's just say that there was a mother that is deceased and she had 4 children. By intestate law, those 4 children are to still receive equal shares, 1/4 equal shares of that property. If there was, let's say that there is a spouse and 4 children, intestate law states that the spouse is to receive certain allowances and certain provisions. First would be, depending on date of death, an expense allowance. Depending on the date of death, it can range from $1,500 to $10,000. Plus the first $15,000 in distribution plus half of the remainder. That is due to the spouse. Then the other half is divided among the 4 children.
So it goes to show that it's really important to say how you want your assets distributed.
Exactly.
Okay, thank you so much. Thank you for the information for the community. Really makes a difference. Okay, how can the audit office help the public when they're going through this distribution process? What is the best way for the public to utilize the resources in the audit department?
First, ensure that they are reporting all the assets of the estate through the inventory. If not, contact us. Feel free to come down to our office and view the estate for yourself, because it is public record and public knowledge, to see what's involved with the estate, to check if there are any claims against the estate. And if you have any questions, ask us. We'd be more than happy to help you. The distribution process can be an easy process, or it can be a difficult process if you don't have all of the information that you need to help you go through it. There isn't really a limit to the information that we can give a personal representative of the estate, because that's the only person that we are really allowed to deal with or to assist when dealing with distribution of the assets of an estate, with information on how to handle that. Besides having an attorney, that's where our limitations come, we can pretty much assist them. It's unlimited what we can do as far as helping them.
And letting the public know that we do not give legal advice.
Exactly.
We don't give legal advice, but we can answer questions about the estate. It's a public document.
Exactly.
So people can come in and review it, particularly heirs. If they have concerns or they want to see what's going on, they're welcome to the information.
What we are is we try to be professional at advising you at what you already know, what you've seen. We just explain it to you, make it more easier for you to understand.
Yes, because it is a process and it can be difficult for some people, especially as they're going through, because it also deals with the personal representative and how they communicate with the heirs.
Exactly.
To make sure that everyone is on the same page and understands what's going on, how things are being distributed, the timeline for distribution, so that they don't have those questions. We have people that call in, and I had a lady that called and she was very concerned about her mother's estate. The sister was the personal representative, and her thought was that, well, the property has been sold and I didn't get the money, and and come to find out that nothing had been sold.
Exactly.
And so just by her making a phone call, calling the office, we can go and look in and see what's going on. We were able to kind of comfort her and ease the pain, because she was very upset thinking that something had been sold without her knowledge. And it happens all the time. Sometimes you have the misunderstanding with the heirs, and they just don't know what's going on.
And you make a very good point, Ms. Conaway. The fact is that it is the personal representative's responsibility to let those heirs know where they stand. And if they're not doing that, that's when the churn starts turning to butter, I guess you call. It gets a lot of people involved. They feel like they're left out. They don't have any knowledge. And the bottom line for most heirs is, when is distribution going to take place?
Exactly.
And they don't understand what that personal representative is all going through as they move in this process. So, as you've said, it can be 20 years to resolve an estate or longer.
Yeah.
The problem is, if one person does not have trust in the person that is representing the estate, they always have that vehicle to go to court, through the orphans court, if they want to be a part of the estate as a co-personal representative, if they want to remove the individual. But the court is going to take the decision that, okay, I think they're doing a good job.
Exactly.
Or, I'm not going to let that property be sold at a price that is way below its value, because the court is trying to be fair to all the heirs, not just the anxious heir.
Yeah.
And the personal representative's duty is to work through the court to have that done. That's one of those examples where sometimes the personal representative may want a lawyer, an attorney, to be a part of the estate or to represent the individual in court, meaning the personal representative, or the estate itself. All those come under the purview of that person having knowledge of estates and trusts and how best to present that to the court, or how best to advise the client what they need to do as it relates to the handling of the estate.
That's where we become limited. When an attorney is involved, we become limited. Even I've had personal representatives, because the audit department is the last phase of closing out an estate and showing distribution, personal representatives call, well, my attorney is supposed to be filing this. I've received this document saying that I'm delinquent on an account, or I need to file this, I need to file that. What I try to explain to them is that the same documentation that the attorney received, you're going to receive because you're the personal representative. Although that attorney is handling that, you are entitled to know everything that goes on with that estate because you are the personal representative. But by law, and we are not legal advisors, cannot tell you what it is, the intent for this attorney, or what it is that he wants to do. That's why you hired him.
Exactly.
So it sounds like communication is key. Whether
Absolutely.
you're working with heirs or an attorney, you know, the communication that occurs helps ease people's concerns and fears.
But it's good that they look up to us. I feel comfortable with that every day because of the calls that we get in, the questions that are asked, that we play a vital part in people making the decisions and going through this process as easy as they go through it.
Absolutely. And again, the phone number for the office is 410-752-5131. And we always encourage the public to call when you have questions. We'll do the best that we can to answer them and assist you as much as possible. Okay. Thank you so much for being here today.
Thank you.
Thank you, Ms. Conaway.
You know, I still cannot believe that Prince is gone.
I know, right? And he was so young. He died without a will.
Really? I didn't know that. I think I need to get a will.
I think you're right.
Let's not make the same mistake. Write your will today. Call us, visit us online, or check us out on social media. And remember, where there's a will, there's a way.
Welcome to another edition of the Conaway Chronicle. Did you know that the Baltimore City Senior Legal Services sponsors a Senior Law Day each year? This is a free event open to all seniors in Baltimore City. Senior Legal Services is a joint program of the Bar Association of Baltimore City and the Baltimore Bar Foundation. Senior Legal Services provides free legal advice and services to Baltimore City residents age 60 and older. Services include legal advice, advocacy, counseling, and education. These services can improve the quality of life for seniors and protect them from exploitation. Senior Legal Services offers this full day of free educational programs, including discussions of consumer protection, housing, estates and trusts, and tax sale prevention. At this event, there will also be the ever-popular question and answer session and vendor booths for seniors to enjoy. Don't forget this event. It includes free breakfast, lunch, and workshops catering to the needs and demands of seniors. These workshops are taught by expert attorneys. The next Senior Law Day will be held in April 2018. Check their website or call to confirm the date. That's www.baltimoreseniorlegalservices.org. Senior Legal Services is housed at 111 North Calvert Street in Baltimore City. You may also contact Legal Services for seniors at 410-396-1322 to get more information. That number again is 410-396-1322. I want to again thank my guests, Gaines Landsey and Calvin Richardson, for joining us today, and our young leader and you, the viewers. A special thanks to the students of the Recording Arts and Media program right here at Frederick Douglass High School for producing our show. Tune in the next time, and remember, where there's a will, there's a way.